I'd like to follow up with something that was said in a prior video blog, and that was said by the guest, John Johnson, a well-respected defense attorney. And you may recall, if you had an opportunity to see the blog, that John said he finds most important what the person said closest to the time of the accident, what the person said at the scene, or perhaps what they said to a medical provider, a first responder, or at the hospital. And that is important, I suggest, and I concur with John. It's important for a couple of reasons. There is, in law, we often talk about hearsay, and hearsay is defined as an out-of-court statement offered to prove the truth of the matter asserted. So many of these statements are indeed hearsay. They are out of court, obviously, because they're made perhaps at the scene, for example, and they can be offered to prove the truth of the matter asserted. It could be sometimes they're not offered to prove the truth of the matter asserted, and therefore they are not hearsay. But let's assume that they are ultimately to be offered for the truth. There are exceptions to the hearsay rule, and they're based on reliability. And you will see in legal textbooks a term, the indicia of reliability. The reasoning in the law has evolved in a very logical way, it seems to me. The reasoning is that the person is most apt to tell the truth after the auto accident has happened, after the fall has happened, after some untoward event has happened. And they are most apt to tell the truth because they have not had the benefit of consulting with a lawyer to consider the implications of what they say. And nowadays we hear the term lawyered up. They're not lawyered up. They also have had no time to reflect, to give a nuanced presentation of what happens. There isn't that motive to falsify or embellish. The event has just happened. And because it's so close in time, it's contemporaneously made often, there is yet another advantage, and that is that the person's memory is fresh. Mind you, years later, a case can be tried or a deposition can be taken well after the fact. But these statements made at the time are not that. They're made within seconds often of the incident, of the accident. So we get over the hearsay hurdle, and statements, by the way, can go either way. They can be statements of the person suing or the statements of the person who is being sued. These are the kinds of things that lawyers who do personal injury work are particularly interested in. Did the defendant say, "I'm sorry"? Not sorry years later in terms of let's have a discussion about settling, but rather did they say, "I'm sorry for causing," something to the effect of, "I'm sorry for causing this accident." We have a sense, really, throughout, that close in time has greater reliability, greater authenticity. And the legal books, the evidentiary books, handbooks of mass law, allow for those statements to be used, and they have a very persuasive effect on settlement, and they have a very persuasive effect at trial. Thank you.